So here today, and thank you all for coming, of course. Here today, we're going to be talking about something called the Heggstad hack. Heggstad is a last name of a family which generated some law, and there's a whole case surrounding this, and we're going to talk about that to some degree. This is not a boring law lecture. For those of you who have attended webinars before, you know that I try very hard to not make it boring. But disclaimer, you're going to hear a bunch of dad jokes and things in here. So apologies or thank yous for those of you that appreciate the dad jokes. And I see some dads on this call, and I know people that are listening that enjoy that. So we're going to make this fun. It's interesting and it's needed. So that's why we're talking about it. So what is the situation that we're dealing with just before we launch in? It's a situation where somebody has a trust that they created. And as you know, with a trust, we like to fill the trust. This is a bucket or a box that you put things in. But what happens when the things that are supposed to go in the trust aren't in the trust when the person who created the trust dies? Then we have a problem because the trust is only in control of the things that you put in it. Anything that's outside, oh, it's not, the trust doesn't control it. Why is that a problem? Well, remember one of the main reasons to have a trust is to avoid falling into court. And the court we're talking about here is probate court in California. And now we have an asset that's not in the trust. Ooh, that's subjected to probate court. Well, wait, Kevin, there's a trust. Yes, but so sad. That's not, that asset's outside. Literally one of the first clients I had after opening our practice 10 years ago. And yes, we celebrated our 10th birthday officially on paper on Sunday. The 10-year anniversary is coming up in July from when we opened the doors and have clients. So go back at time machine 10 years ago, July, August. One of the first clients we had was a beneficiary who called up, and there was a trustee, but it was a trust administration. Aunt died, and Aunt had a trust. Aunt didn't have that much, had her home and some bank accounts and everything. And so our client thought, oh, well, I'm the trustee. This is going to be easy. Came to find out that the trust was empty. So it's just a trust. No work was done to move assets into the trust. So what happened was we had to deal with probate court as well as dealing with the trust in addition. So it was a double administration. We dealt with probate, and then once probate put things into the trust, then we had to deal with the trust administration. So 3-year process to do something that the aunt was trying to avoid from the beginning, which is the time delay, and it was super expensive. So that was a big problem, and now we're going to talk about the solution to that problem, because that client isn't alone, because this happens every day. Someone passes away, and then the family finds out, the trustees find out, oh my gosh, there are assets that are not in the trust, whether it's a bank account, whether it's an investment account, whether it's a piece of real estate. They're finding out on title wasn't in the trust. Why does that comes as a surprise? Obviously, that you think, well, there's a trust that should have been in there, but there's lack of communication, right, in life. So your parents, your relatives, other people create the trust and are very private about their finances, and then nothing is shared and communicated, and then you find out later that things weren't done. So there was no involvement in the process. This is not a commentary about, well, that was silly, stupid, dumb, they should have done this or that. It's just the reality. The reality situation is there's a lot of this that happens on a daily basis. We experience it in our office when people are calling up and their trustees and mom or dad passed away who weren't our clients, and now they're calling and saying, we need help because we're finding out that we thought we could do this, it would be easy, but it's not, because the house, the accounts were not in the trust. Or some of our professional colleagues out there that work they're realtors or they're in title, that they're finding this problem out when they're trying to sell houses and they're trying to get title insurance, and they can't because the property is not in the trust. It's still in the person's individual name. And now we have issues that flare up in the middle of a 15-day escrow or even a 30-day escrow, you're always finding out at the end, even no matter how long of it, 60-day escrow, then all that stuff happens. There's always a rush at the end, right? Now the escrow company is saying title needs this, and this. You're like, well, wait a minute, we've been in this escrow for 60 days, and why is it the last week that we're actually getting all this paperwork done? And there's such a stress and push. So we see a lot of escrows fall into problems, and that's, the title officer, realtor is then reaching out to our office, and we're learning about these problems, and we come in and we're the solutions. So that's one of the things I love about being a lawyer is that we're solution oriented, and we're taking the Rubik's Cube that you find yourself in and helping you figure it all out. And that's why I became a lawyer. So those of you that don't know me, I am a husband, father, and attorney at Snyder Law, the firm that my wife and I created 10 years ago to help families just like you solve problems, whether they're simple or complex. Your Rubik's Cube, we will solve it, and we'll help you solve it and walk through that. That is the genesis, because we have a family. Imagine that attorneys are humans. They laugh, they make funny jokes, they like to have fun, and they also have families, and life happens to them too. So I think life happened to our families over the years. Certainly, what really instigated this was my grandmother passed away without any planning. There was a lot of messy situations, as you might imagine, as a result of that. And that really encouraged us to get our planning done and then help others. And we decided, hey, we can do this professionally. We're passionate about it. So that's what you're going to get here. My passion about helping you solve this particular problem today of not having an asset in a trust. And now the trust maker, the settlor, or the grantor, whoever you want to call it, the person who made the trust, has died. So that's what we're going to learn. We already talked about the problem of probate. We're going to touch a little bit more deeply why it's a problem, just to remind you why, other than just following the general rule of thumb, is that we want to stay out of court in life the best we can, any type of court, certainly probate. What is this Heggstad hack exactly? How does it work? We're going to talk to you about that. We're going to talk to you about that roadmap of how it works, why it works, how we get that done, pulling back the curtains just so you better understand it. Future proofing your legacy, being proactive. How can we be proactive to avoid this particular problem other than simply recreate the trust? That's not enough. And I'll walk through some specific case examples. I know I mentioned one already, but we'll go through the full thing. Here's the case scenario, what the problem was, why it was a problem, and how we solved it. Then, of course, like always, we're going to have Q&A at the end. So as Lara mentioned, if you have questions, just put it in the chat. Or the question box. She's managing all that. She's collecting all that. And you will get all that answered at the end. So stick around. So you're going to want to stick around because there's always really good questions there. And we're going to want to hear the examples of how this really works and how we really have helped people, because that's going to stick more in your mind. Don't worry, we're going to get you out on time. I've been challenged to get us done by 1:30, including Q&A time. So that's my challenge and promise to you. So you guys can go ahead and wonderful weekend. So why is probate a problem? Why missing assets matter is because if assets are missing from a trust, we go through a probate. Well, probate's a problem in California, and little asterisk. This whole webinar is for people that have assets or live in California. So it's California law. So if the trust is out of Pennsylvania and the assets are in Pennsylvania, this is not for you. Heggstad is something unique to California. But your person might be out of California, but the assets in California, that's okay. Pay attention. Don't leave. Of course, if the person that passed away is in California, then stick around too. So unique to California. So in California, when we have an asset left out of a trust, now it's in the person's probate estate. Think about concentric circles. All right. So if we think about ownership of what is in everyone's estate, we have a big circle. In that circle, everything we own. including this shirt that I'm wearing. If we're talking about Kevin's probate estate, the shirt on Kevin's back to investment account to his professional corporation, Snyder Law, those are all things from little to great that are in my probate estate because my name's attached to them. I have ownership over it. Then even if I jointly own things with somebody else, like my wife, it's still part of my probate estate initially. Then we got to think about, well, there's little concentric circles within the big one, like a trust. So having a revocable living trust, joint trust, family trust, revocable trust, whatever you want to call it there, that's the first little concentric circle. So there might be items inside that. And if you have a business that might be owned by your trust, then that is another little circle inside the trust bubble. So you see these concentric circles. Sometimes I talk about Russian nesting dolls, but Russia's already in the news too much these days, so we won't even talk about that. So concentric circles. So when we look at a concentric circle being a trust, then if the item's not in that trust, then it's in our big circle probate estate. So the law says if it's in your probate estate, guess what? It's got to go through probate court. And the California law has to determine and decide how it is then passed down to the next generation or the next of kin, because it might not be the next generation. It could go to a brother or sister. It could go upwards. It can go to parents. So how does the asset succeed? And the California law has its family tree lineup of how the default plan is. It's a family tree. So whoever is the oldest surviving survivor on the family tree inherits. So an example, you're married, it goes to your spouse. Sometimes it goes to your spouse and your children, depending on what type of property it is. So spouse and kids first, sometimes all spouse, sometimes divided between spouse and children. If you don't have a spouse, it goes to your kids. You don't have a spouse or kids, then guess what? It goes to your grandparents that might be alive. And if not your grandparents, you don't have a living grandparents, then it goes to your living parents. You don't have a living parent, then we look at your siblings and then down to nieces and nephews. All right, so we kind of expand that family tree out. Then when we find somebody living on that, then they inherit or the generational plan inherits. So for example, if you have multiple siblings, you don't have married kids or grandparents or living parent, then you have multiple siblings, they all receive equally what's in your probate estate. So that's how it works. That's what the law, the default plan is. A lot of little pitfalls in there, of course, because what happens if your beneficiary, your heir, is incapacitated? What happens if your heir is somebody that you wouldn't want to receive something that you have, whether that's a child that you no longer have, you have an estrangement, right? And whatever it's a child, whether it's a sibling, whether it's a parent, there's an estrangement, or specifically, we're talking about parents. What if they have a disability, because they're receiving Medi-Cal, and how might this impact Medi-Cal? Are they still going to get benefits? If they're a veteran or surviving spouse of a veteran and they're getting VA benefits, this might impact them? And we're like, we wouldn't want that. They're a minor. So parents that have minor children or grandparents that have minor grandchildren, this is a real issue. So your grandchildren might inherit and they might be under 18, and that is going to create a probate involvement until they turn 18. So when we talk about length of time, a probate takes about 18 months on average to go through normally. It is extended out by the age of the beneficiary. If the beneficiary is a minor or they're disabled in some way, guess what? Probate is extended for a long time until the minor turns 18, number one. Or it might be even longer than that if we have a disabled beneficiary that is incapable of making decisions, then that's going to extend out the probate. So we want to avoid this at all costs. Some things that lead us into probate, because like, hey, Kevin, we did the trust thing. So like I said, that's not enough. So if we don't move assets into the trust, we properly fund a trust, then you're going to have the asset outside at the time of the death, and that's a problem. Commonly, we see that happen with real estate. Why? Because the title wasn't updated for whatever reason. It was not updated to reflect that the trustees of the trust now own the property. Or another pitfall is that you go through a refinance on the property. Did your trust, it was properly funded into your trust, the deed's accurate, says the trust owns the property. Now you refinance and the lender says, oh, and they're in the process, they take your house, do a transfer deed back to you as an individual or as a married couple, and they leave it there and they never put it back to your trust. Maybe they tell you they're doing this and they're going to put it back in your trust. It doesn't happen. I've seen it all ways. Or you have no idea that they're doing that. You don't realize that. Or you do realize that and they tell you, we're not going to put it back in the trust, but you're going to have to, and you never do that. All these things, of course, are realized at an unfortunate time when the person on title has already died. All right. So for you out there that have parents, one of the things you want to check with them is, have they done a refinance and have they checked title since the refinance? Because those are some nasty surprises. Like mom and dad had a trust, they put the house in the trust. The trust says the house should be in the trust, but mom and dad refinanced a few years later, back during COVID or pandemic, right? When the rates were low, everyone refied. Well, guess what? There's a lot of houses out there that are not titled in the name of the trust, even though people think that they are, or they were once, right? There's this false sense of security. So a takeaway, right? One takeaway here for you guys after you get off this webinar is go find out if your home is titled correctly, even if you think, yeah, it's in the trust. Well, get that piece of paper out and boom, and especially if you've done a refinance. I don't care. You did a trust, go, and as long as you can see that there's a deed that says the name of the trust is there, excellent. Now, if you've done subsequent to the date on that deed, you've done a refinance, you got to confirm that your house is still titled in the trust. The same goes for your parents. You're going to want to go ahead and do that. So that's the second part of that homework is checking title out, because you don't want to be surprised when mom and dad die and now you're like, house is supposed to be in trust, but it's not. Shoot, we should have checked ahead of time. Another time, pitfalls, this comes in with agreements of things. So a good example that happens quite frequently, parents buy a house for an adult child. Why? Hey, look at the market. It's hard to get in the market right now. Kids coming up, they haven't had a chance to be able to save a good down payment, $200,000 down payment to be able to qualify for the mortgage that they need. And so they don't have the money to do it. But the parents have the finances to do it, to get a good mortgage rate, and they could afford the mortgage, or the kids can afford the mortgage based on income, but they don't have the down payment, right? Or there's bad credit, whatever the deal is. Mom and dad buy the house, or a parent buys the house. Now they own the house completely, or they own part of it. Most common is, hey, the kids and the parents own the house together, and everybody is on the mortgage together because they needed to have a co-signer basically to qualify for the loan. And in that, there's a conversation in that, oh yeah, this house is really yours, John or Jane. Hey kid, it's yours. We're just on there for paperwork to get you a better loan. Mom and dad then die. And then we find out that it wasn't joint tenants with the right of survivorship. Mom and dad actually had just a percentage of the property, whether it was 1% to 50% as tenants in common. Well, guess what? That doesn't revert to the kid who also owns the other part. Now, even though there's a verbal agreement, hey, this was all going to be yours, mom and dad didn't have trust planning, or mom and dad had a trust, but they didn't put their portion of it in that trust. And that trust wasn't updated to say, upon our deaths, our interest in this house goes to Jane or Johnny. So we have a problem. So now we have to probate half the house that Johnny or Jane live in to make sure that we're fixing title. And what happens if there are other siblings involved? That's a situation, right? Even though, hey, there's a verbal agreement mom and dad and I had, and you can look at the mortgage note, this all checks out. Worse when mom and dad just buy and only mom and dad are on title, or only mom and dad are on the note. That's the worst situation. And we've seen that where, well, there was always an agreement. We just didn't get around to fixing things. And we're in the process, but nothing got finalized. Now, Jane lives in a house that is going fully into probate, and there are creditors on dad's estate. There's other children. Can Jane end up keeping the house? She may lose the house because they have to sell the house in order to divide up the assets because she can't afford to buy her siblings out or buy the estate out fully. Or there's too much debt on the estate. So those are common mistakes. Happens with businesses too. So you create an LLC, a corporation, you don't fund it into your trust because, oh, I'm the member, or me and my wife are the members of this LLC, or we are partnering with somebody else, a friend, a colleague, and we just create the agreement. Well, guess what? Your interest in the LLC, the membership, or the shares in the corporation need to be in a trust if you want to avoid probate. The bylaws, the operating agreement is not can, but most likely does not say anything about succession if one of the owners dies, because most of them are formulaic. The CPA has done it, or you've gone on LegalZoom, or maybe you've done none of that. You just filed articles of organization or incorporation with the Secretary of State. Then that is not enough. It doesn't, you have an interest there. Your business has value, if only it has a bank account that has money in it. Now, if that bank account with money in it, you're not going to get access to after you die. Your business owner might have access if it's a partnership, but let's say it's not. It's a sole member. It could be a medical practice. It could simply be a consulting business. And now there's money in that account. Then your wife, your trustee, whoever it is, your kids aren't going to be able to get access to the account. The bank's going to freeze that account. And then they're going to say you need to get letters testamentary, an order from the court that you can come and get access to the money. So that becomes a problem in that situation because LLC wasn't, or the corporation wasn't funded into the trust. Or you have some sort of partnership agreement, right? Same deal. Equity in the firm, equity in the wealth management company, all not tied to a trust, now is in probate. And how is how is that interruptive? Well, when we're talking about business, it could literally interrupt business operations. It could be a problem as far as if there's a sole member of a business, the owner dies, well, can the business still operate? To some degree, maybe the next day, if you have staff, you have a team, but at some point, there's going to be some document that only the shareholder, the owners, or the member can sign, and then you're going to run into a wall. Maybe it's some sort of agreement that needs to be signed to continue work and have the client continue to pay the corporation or the business. There's going to be a sale of assets. If you have a rental company or you have a rental in an LLC, how can it be sold if you need to generate cash in that situation? Example, LLC owns some rental units up in, let's say, Big Bear, and smartly had an LLC for liability protections, but the membership wasn't transferred into a trust. So the member of the LLC dies frequently in an accident. Now the family doesn't have access to the rent, doesn't, because it's going to be frozen in the bank account that the LLC has, and doesn't have authority to work or contract with any of the tenants. So that's going to be a problem when it comes to trying to extend leases and just the management. Oh, there's a management company. Okay, that might give a little bit of runway there, but you're not getting money out of the account. And look, you don't want that rental property. It's a hassle. It maybe even is a liability that you want to get rid of, from a liability like, hey, I'm worried about lawsuits, or it's a money pit, I want to sell it. Well, guess what? You can't sell it because it is in the decedent's probate estate. The owner died, and the LLC is part of the assets. There's the authority has to be pretty clear, and it has to be determined by a court in that situation. So we've seen a lot of that, down to bank accounts for businesses, a medical practice couldn't be sold because they didn't have authority to sell the medical practice. It was sole practitionership. But guess what? The sole practitioner uh, interest wasn't assigned into a trust. So everything else was in the trust, but the medical practice. Well, we didn't have a corporation. Well, you can still transfer and assign a sole proprietorship over, and that didn't happen. So that affected the ability to sell the practice at the best time, which is sell the practice when there was an active book of patients, and then not being able to get access to an account that was getting receivables, and their money was coming in, and they couldn't even pay rent, and lost the building that they were having the medical practice. So just because now the medical practice is in probate. So costly delays, stress, and court involvement. That's what we're working on because probate is a grinder, a meat grinder, if you will. Probate takes your assets that are in that big circle and puts them into this meat grinder. Out spits probate fees, and then it's generally an ineffective or inefficient way to manage tax. So if it's going through probate, you're paying the highest level of tax in there because you don't have the flexibility of doing anything strategically, and so less money pops out for the heirs. It's a lengthy process, as I mentioned. You don't have control. When I say my example, you have passed away, but your people that you left would leave in charge, they lack control because why? There's a person in a black robe that they're in charge. That's the judge. They're in charge, and that judge has a little minion called the probate referee that runs around, that really runs the show behind the scenes. And so you're beholden, or if you are the proposed executor or you're the trustee in our example today. So you're named as a trustee, and now you've got to go to court to answer to the not the probate judge and the mini me in there. You got Dr. Evil and mini me that you gotta answer to. That's a problem. You don't have control. They control the system. And really, if you're in law, you really know that the clerk controls the whole thing. But so you can't just make unilateral decisions. It's public. Why is this a problem? Because now there's a venue for creditors to um, say that the estate owed them money, and they can come after it, even if the debt was from years ago. And they're like, and they're going to know about it because you have to publish in a legal publication that there's been a probate, so people can find out. They can look it up in the court system that's open to the public. You can go and search. Then it's not a hidden process. So, hey, there's this debt from 5 years ago. All of a sudden, that creditor is coming out and saying, hey, this person who died owed me money. Or that it's open venue for some sort of conflict of, I don't like the fact that you executor are trying to be the executor. I think I should, or I should be an heir, blah, blah, blah. So there's a lot of, you opened it up saying, the Colosseum's open for battle. Come on in. All ye who enter here, beware that there is going to be some fighting. And so when we have a probate, that's always the prospect. Even if we're like looking at it, go, who's going to fight about this? Guess what? When people die, sharks are out there smelling blood in the water. They're coming. There's no asset protection from a standpoint of now things pass on. So we're like, look, we wanted that business, we wanted that house to be passed on to our kids, but we were worried about their spouses. We didn't want them to lose it in a divorce or a lawsuit, or a bankruptcy because the business folded and had to file bankruptcy. We didn't want them to lose other assets. And that's why you did the trust, and you put all those provisions in there, and we did that hard work, and we put everything in place to achieve those outcomes. All get tossed out the window because the business wasn't put in the trust. The house wasn't put in the trust. That nice big investment portfolio not put in the trust. Now that's subjected to all of those outcomes of lawsuits, divorce, bankruptcy, because it's going to a individual beneficiary in their name. So it becomes exposed to liability risks. 18-year-old problem. Remember I said the time period to the lengthy court process and 18-year-old problem are connected. So there's a connection there. The money is going to a minor beneficiary, whether that is a child under 18, a grandchild under 18. then the court's going to be involved in monitoring the inheritance with a guardian ad litem and a professional fiduciary, two professionals that need to be paid until they're 18. So that extends out the length of the probate. Let's think if that grandchild is just born, that's an 18 long probate. And then at the end, they get the publisher's clearinghouse check. This is now yours. You have full control and access, even though at 18, you're not really mature enough to manage and make smart decisions. Tip of the spear, maybe 1% would survive that. All right, there's 1%ers out there that'll be smart enough, responsible enough, and have some good people surrounding them to guide them to make good decisions, get the right advisors to help. They'd be okay. The other 99% are going to blow it within 2 years. True statistic out there that inheritances received by young adults, 18 years of age into their early 20s, are going to blow their inheritance either on a shopping spree or ill-advised decisions, investments, with and lack of financial acuity or education, because we just don't do that in this country. We don't talk about and educate the youth on financial responsibility. So guess what? That's gone in 2 years. So we don't want to have a rags to riches to rags situation where grandparents work so hard, they went rags to riches, and then it passes down to grandkids and it's now rags again because they misspent it. Same thing with children. Parents went rags to riches, but the next generation doesn't know what the heck to do, and it goes back down to rags because it's all gone. It's also expensive. Probate is for every $1 million of value in an estate, it's going to cost about $50,000. Half of that money goes to the executor, the other half goes to the law firm. So probate is really lucrative for law firms. Not gonna lie, we do probate. It can be lucrative. We don't want you to fall into probate, but probate happens, right? It's like the Forrest Gump origin of what, SHIT happens. Probate happens. It can be the same thing. Probate's actually a lot worse than stepping into some SHIT. Is you're really stepping into it because it's super expensive. You're just saying for every $1 million, I'm giving a law firm $25,000, or I'm allowing that to happen. That's an expensive plan, and you just did all this great planning that wasn't necessarily cheap either to put all these things in place, and it doesn't matter. Your estate's got to cough up $25,000 for every million to the law firm. There's way around that, right? So we want to avoid those unnecessary costs. And that's just the financial cost that's built into the statute. We're not talking about lost opportunity or opportunity costs like lost business, losing the value of the business. Seen this happen. So the business was stuck in probate and it lost clients, diminished in value, and it got sold for parts. $11 million business got sold for parts. So there's expense there. So that's why we want to avoid it. How does the Heggstad hack work? How do we fix this situation? So we've already talked about California Probate Code 850 to this point. So just know that we've talked about it. So we also talked about the problem. So what we need to do is and we have this situation, a trust and assets outside of the trust, and there's a death, and we're like, shoot, how do we posthumously, big word, there's your $10, your $1 million word, after death, put it into the trust. Oh, Kevin, I know how. It's called a pour over will. I heard about that. We poured over. You did such a great job when you're helping us in your other webinars of talking about pouring it over. It's like a decanting a wine situation or a pour over coffee. We take little colanders and we take it at the colander of not being in the trust, the colander of the trust, and we just pour it over into the trust afterwards, right? Yes, that is the concept, but it does not happen automatically. It is a catch-all in the sense that it'll be helpful, but there's still some steps of going to court that you need to do in order for that to happen. Great, glad we have it, but there's still court. So, of course, underlying all this should be making sure your assets that can be in the trust are actually in your trust. Back to checking your deeds. Go check your bank accounts, your investment accounts. Designated beneficiaries on life insurance, 401ks, IRAs, Roth IRAs, deferred compensation plans. We want to make sure that our assets are aligned with our trust, right? Because then that's easy street. Then it works without talking about this. But if we're dealing today with a situation of, oh my gosh, my parents passed away, their house was in the trust, what the heck do I do? Because, I have to pay back the mortgage company for the reverse mortgage. Or the lender found out about it and they want to know what the heck we're going to do with the house, or they're going to start foreclosure process in 90 days. I don't want to lose the house, but I can't do anything with the house. I can't sell it because I don't have the authority as a trustee to do that. So what we need to do is file a Heggstad petition. Heggstad is the name again of the family that there was a case this was about. The Mr. and Mrs. Heggstad died, and then their estate, they had a trust, and there was an asset outside of the trust. And so they litigated this, and now this comes up. And the ruling in that case was, hey, you can go to court and ask the court in a petition to posthumously transfer assets into a trust, as long as we can prove the intent of Mr. and Mrs. Heggstad that they wanted to do that. And if we can prove that was their testamentary intent, their intent during life, that this was the outcome that they wanted for that asset that wasn't in the trust, then we'd be glad to bypass all of probate. And we'll just sign an order that says, put it in, this is transferred into the trust. The big thing is we have to prove intent, because just because they have a trust and the asset's not in trust, the trust itself is not demonstrative of intent. Because there also needs to be a will, because the asset isn't in the trust. So the will has to say, well, this is the intent. That's an example. If there's no will and you just have a trust, we have to look at timing. Like, what if you created the trust and then at the time you didn't have that asset, and then subsequently you got that asset? Well, there's two different interpretations. One is I had a trust and I would have intended all my assets to be in the trust. That's why I created the trust. And the fact that I didn't do it, well, that was my mistake. And I had the intention of doing it by virtue of having a trust. The other is, I know I had the trust. There's a reason specifically why I didn't put it in that trust, because I didn't want it to go to the beneficiaries of that trust. So I specifically kept it out. And I probably should have created another trust, but I didn't. And so it's so sad it falls into probate. But guess what? I know it. I didn't want it to go into that trust. So it's unknown. The court you have to be able to prove intent. How we do that is by filing a Heggstad petition. We say, hey, court, instead of doing the full 18 months or longer of probate court, we can prove intent, and here's how we improve intent. It was the intent of the people that died, the decedents, who created the trust to have this asset in the trust. So now that we've proven that, and we can prove it with exhibits and do it all in paper, we want you to rule that you should sign an order that I can now go back to the county recorder's office and record, or go to the financial institution and give, and we can get everything transferred over to the trust. All right, so that's the idea. It's a shorter process than the 18 months. Now we're looking at probably about 6 months on average. That's a lot better. But hey, Kevin, there's still problems, because remember I said that I got 90 days. I don't have 6 months. I have 90 days. So this is not foolproof, right? It's not a foolproof process. And oh yeah, the asset itself, we had this situation where we can't prove intent. There's no pour over will. The asset was the house was purchased, or the account was opened after we created the trust. So we don't have that particular intent. And the last is the beneficiaries don't agree on the outcome. Why? Well, remember I said there's a reason I didn't put that in a trust. Well, we have beneficiaries in the trust, but they're not all the potential heirs. Think about blended family. Well, I just wanted these kids were my kids to inherit. And so I wouldn't want that. But I have these other kids maybe I adopted along the way, or you have a family and you have some children that you don't have the same relationship, or they don't have the same need. So look, I left it to these kids, but not those, for the reasons that these kids have the greater need, or these are the kids that have kept in touch with me. I am estranged from this one over here, so on and so forth. Or again, with a blended family, it's a spouse. Like, look, I want that to go to my kids, not my new spouse. My new spouse is fine, that financially, otherwise, or I'm leaving my spouse, him or her, some of the assets over here, but these specific ones I want to leave to my children, not to my spouse. And so if all beneficiaries don't agree, then this becomes a contentious process. And then it becomes longer because we have to have hearings and people have to testify, and it kind of becomes a little mini trial. So we're trying to avoid that. So it's not foolproof, but we can sure as heck set it up so it's a lot better. And the number one way we can do that is by making sure we have a pour over will that is close in time to when assets are secured or purchased. Think about, you buy a house. Well, if your pour over will has a date from 5 years, 10 years ago, well, your trust is going to have a similar problem. You're going to want to update your planning accordingly. So that's going to encourage better results. Certainly, we want to make sure that assets are funded into the trust. So that's going to create different results. So here, what we do to secure the Heggstad, in my example, where house is outside of a trust, mom and dad passed away. Now we have the house outside. How do we draw it back into the trust? Mom and dad had a revocable trust. They have the pour over will. So we've identified the asset that was left out. And we want to identify all the assets at that time. So we got to do our homework. Like, did we go through all the potential paperwork? Do we feel like we exhausted all abilities to track down assets and see which ones were in the trust, which ones were out? Because we only want to do one of these. We don't want to find assets later that were just in someone's individual name outside of the trust and then do another Heggstad. Why? Time consuming, inefficient, costly as well. So let's do it all at once. Identify all the assets that are outside of the trust, whether it's a house, business, bank accounts, investment accounts, etc. Now we want to list that all in the one Heggstad. We want to make sure that we can prove intent. So if we have a pour over will, we need a pour over will in there. But if we don't have a pour over will, are there other ways that we can prove intent? We have declarations from witnesses, etc. Then we want to put the petition together with all the exhibits and all the things and file it with court. And then we get assigned a court hearing. Now that court hearing can be really easy if part of putting the petition together is that we're getting declarations from heirs that say, I'm not contesting this. I'm cool with this. This is great. So if we have those, we want to put those together because the type of hearing we get is going to be uncontested or contested. So if we have contested and there's some challenges, well, get ready for a battle. We're back in the Coliseum, so pick your weapons wisely. And at the end, of course, if we have the no contest situation, then we much faster will get hopefully a favorable ruling that, yes, I can see the intent is there and you did all the paperwork right, and there's no contest. Here's your order. Now you got to take that order that says, the order is going to say literally, the house now belongs in the trust, right? You got to record that, the recorder's office, or you got to take that order to the bank or the financial institution. And if you have to fight in the Coliseum and you're the victorious, then the court's going to give you that order too. It's just going to be further on down the road. And by the way, that order, just by the way, doesn't happen that day in court. We have some time lag to get the order. Just the way it is. That time lag can be significant. It could be 3 to 4 weeks. So I'm going to come back to these case studies here because I just want to point something out between Heggstad and super Heggstad. And yes, I said super Heggstad. So you see, Mr. Macho super person here. It's a real thing as far as the outcome, the name. Don't go look up super Heggstad. It wasn't in someone's last name. There isn't a case that says super Heggstad. It isn't legal doctrine. It is Kevin. It is Snyder Law that is creating this idea of super Heggstad, or the name. The idea is not unique to us, but we're calling it super Heggstad. So it's just easily distinguishable from regular Heggstad. We have super Heggstad. So regular Heggstad, you see the timeline here. We go through all the different steps I just talked about. It could be 12 to 20 weeks. Who wants to wait 12 or 20 weeks? Even even if it's just like, there's no other consequence other than my patience, that's a long time. But sometimes we need access. Like we need access to the money. Either personally, the beneficiaries need access to money. They're like hurting. They're paycheck to paycheck and just got fired. They got laid off and they need some money, and there's money sitting there to help them, but they can't get it. And they're gonna get evicted. They're gonna starve. They're in financial dire straits. We want to have access, right? Or there's bills that the trust has to pay, whether it's a tax bill, whether it's a medical bill, whether it's the mortgage. And oh shoot, we're going to lose assets like the house if we don't get access. We're going to lose the business if we don't get access. We can't wait 12 to 20 weeks. Sorry, it just ain't happening, particularly with the foreclosure situation. Remember that 90 days? Yeah, or the lender saying, hey, you got to pay back the note or else we're pushing you into foreclosure. You can literally lose that asset, and you need to get access to. I need to sell the house to get liquid assets, the cash, into the trust so we can use it for other purposes that we need. So there's some urgency. Guess what? That's the birthplace of the super Heggstad. So the whole process can be done as quick as 2 weeks. No joke. Done it. All right. Done it in 2 weeks. Amazing. And with that, we'll go back to the examples. But between 2 weeks and waiting 20 weeks, 12 to 20, which are you going to choose, right? Of course, you want the super Heggstad. Who wouldn't? It's going to be really, really important and detrimental in some cases to have the quick turnaround. Now, the quick turnaround can't happen unless you do the super Heggstad in this situation. Super Heggstad is limited to the people that know how to do it. So a lot of trust administration, probate, estate planning attorneys only know how to do regular Heggstad. Regular Heggstad is in their county. Orange County, asset was in Orange County. I'm an Orange County lawyer. I'm just going to do it in Orange County. Guess what? Orange County does not do super Heggstad. There's only one county in the great state of California that handles super Heggstad. That's Contra Costa County. That's why we have an office there. So you have to be local counsel to do super Heggstad in Contra Costa County. So that's why we are local counsel. That's why we have an office there. That's why we practice law in Contra Costa County, so that we can pursue super Heggstad for our clients. Anybody else that is not local counsel cannot do that, or they have to hire us on to do that. That's a way that we get business, or other lawyers up in Contra Costa that are doing that, or are practicing there, get business as referrals, so that they do it on behalf of the client for the other attorneys. So if you know an attorney that's an estate planning attorney, that's trust administration and probate out there, would love a connection, because they might not know that you can even do a super Heggstad, because that process is not very widely known. And also, they might not be able to practice up in Contra Costa not because they're not licensed. It's not a county license, it's a state license, but they just don't have that familiarity, and they aren't in a position to have an office there. So all that would be a great referral for us. We happy to help. Or if you know somebody that is on dealing with this issue, we're going to deal with it super Heggstad way, because it's a lot faster. We don't do old school Heggstad. We do super Heggstad for everybody, because it's not about the rules being different as far as the other stuff. It's just the timeline. Everything else is the same, but it needs to be uncontested. So if it's contested, sorry, we got to go regular Heggstad, and we got to go to the Coliseum and battle it out gladiator style. But otherwise, we want super Heggstad. So here's how it works before we open up for questions. First problem, and I start here in my case study, because this is like everyone thinks houses. Houses left out because of the reasons I mentioned, the refinance, or they never put it in it, or they purchased it. They have the trust. I didn't mention this. This does happen. They purchased they have the trust. They did all the hard work. They had a house that wasn't in the trust. They sold that house, or they went out and then went out and bought another one, or they kept that house and they bought another one. But when they bought that new real estate property, whether it's a vacation home investment or it's their new primary residence, they didn't close in the name of the trust for whatever reason. Now it says John Doe, Jane Doe as husband and wife, as community property, or as joint tenants. and that's the title. It's not in the trust. And then they forget that they didn't do it and they were going to go put it in subsequently, or they decide, that's a big hassle. Whatever the deal is, they die, and now it's in the probate estate because both of them have passed away and not in the trust. So we'll get to that in a second. This is the bank account. Why is that important? Because in California, we have a financial threshold, 184,500, 184,500. That is the financial threshold, above which, if the aggregate of your assets of value are that are above that number, 184,500, so 184,500, then, and if it's by 1 penny, then all assets are frozen. So we're not talking about houses, that's separate. That's including houses though, but this is where the pitfall is. Like, we have a bank account with $200,000 in it. Guess what? That's going to probate. And guess what? You had a car, the car wasn't going into probate, but now because we have a probate, that car is sucked into the probate. So generally, cars are not probatable assets. We go to DMV and deal with it, unless we have a probate that we have a probatable estate. Then that car gets sucked into the probate. DMV transfers won't work, or they'll become invalid. So that becomes an issue. And so same with it sucks in other accounts, like, oh, we only had 12,000 in this other account. We can't deal with that separately. That gets sucked in too. It's like this big vortex like that. So I've seen this happen. It was 200 grand. We can't, Bank of America won't give us access because it's over $184,500. So these people don't play. They're not going to say, oh, it's so close. It's a mulligan. No, or mulligan, that's not the right word. It's a gimme. No, it's not closest to the pin here. You have to get it in the pin, in the cup, I mean. All right, golf analogy is done for the day. Clearly, I'm not really good at golf. But so here in my example, the problem was $350,000 bank account wasn't properly titled. Now it's in probate. However, Ryan needs to get quick access to it to cover funeral costs and support his younger brother. Yeah, funeral costs, no joke. Mom and dad want to be buried. There's a burial. We're talking 30 grand plus here for the whole kit and caboodle. Guess who pays that out of pocket? Ryan pays that out of pocket on his credit cards, probably, because he doesn't have that disposable income and savings because he's got kids paying for school and not a lot of disposable income. And even if he has the income, it's coming out of his savings. He wants to get it back in because he might need it. So, but he can't get access to the account to pay himself back because they're frozen because the parent died, doesn't have access. And he's got to support his younger brother who's got a lot of needs because he's younger, got parents are supporting him for school, place to live, or maybe there was a disability there, or he's just a failure to launch and they were financially supporting them. Now, or he's got illnesses, a lot of medical bills. Can't do that because and Ryan can't afford that to continue to financially support his brother forever. We need access to that money. So instead of doing an 18-month probate, we do a Heggstad petition. We do a super Heggstad petition, and we get in just a couple weeks, we get that order that Robert, who died, intended this bank account to be in his trust. And so now Ryan, who's the trustee, is able to have access to that bank account. Because he's got the order, he can go to the bank and say, here, unfreeze the account, which they will, and now he's got access to 350,000. He only had to wait a couple weeks. He did not have to go 18 months, and he certainly didn't have to go regular Heggstad, which we said was 12 to 20 weeks. So that was helpful. Case 2 is now we have the house. So this is where for sale family home. That doesn't sound good, right? We want to avoid that. Now, when I encourage you to think about this also for sale of business as well, or business sold for parts, not for true value. Same concept because of what's going on, but we're just going to focus on the family home. So James and his siblings' family home is valued at 1.2 million, right? Wasn't transferred to their father Michael's trust. But all right, that's a problem, as we mentioned. But the problem is that there's a mortgage on it because there was a reverse mortgage on the property, or there was a traditional mortgage. Either way, line of credit, they got to pay that off, or they're going to move into foreclosure proceedings in 90 days if that's not done. 90 days. We don't have 18 months. We don't have 12 to 20 weeks to wait around for this. We got 90 days and they told us that 30 days ago. So we got to move. Or we're in the middle of escrow and this is a great deal. We don't want to fall out of escrow and go through the whole process. That's going to impact the sale price and everything. We got to fix this before the close of escrow. So we step in, we file a super Heggstad, we get it done within the time of escrow, within 2 weeks, 3 weeks. Now 2 weeks, that's the fastest we've seen it. Now it could be a little bit longer, 4 weeks. The longest I've seen is 6, but still we're well shy of the 12 to 20. So we're doing it quickly here. Now we have an order from the court saying that title belongs in the trust. We record that, not a problem. Why? Because now we can sell the house and gain access to the equity. Now we can refinance the loan that was there. If it's a situation where it is a reverse mortgage, we can have, or any mortgage, if it's a traditional, somebody is going to assume the mortgage. The trust can assume the mortgage, person can assume a mortgage. Reverse mortgage, it's a little trickier because now we have age restrictions over who can assume that, and you have to live in the house for that to happen too. But we can sell the house to pay the bank back. All that, so we're not losing the asset to foreclosure. Done. We saved the kids. We saved the grandkids. We saved the beneficiaries of the trust. So that's the benefit of the Heggstad and Super Heggstad. We've already talked about intent and timing and how that matters. We've talked about the challenges that petitions could face. And if it's not uncontested, we have heirs that disagree with this happening because they don't want the property to go in through the trust because they might be disinherited. And we talked about timing of when assets are purchased. How do you future-proof your legacy? We've talked about that. Fund your trust, review your trust, be diligent about it. Every year, look at it. After this webinar right now, this weekend, heck, this afternoon, don't even start the weekend. This afternoon, go and check how your assets are titled from your property, from your accounts. Look up your life insurance, your insurance policies, who's the beneficiary, your retirement accounts, who's the beneficiary. Make sure it's all aligned with your trust. And so there's not going to be, and then if anything's overlooked, you can fix it. If you need help fixing it, we're here for you. We're here for you. We can help you fix it. So fund it. Make sure you do your planning, of course, at the beginning of that. Make sure you have a pour-over will, and so on and so forth. If you purchased a house after you or acquired an asset after you've created your trust, that'll be time to go look at, make sure the title is consistent. Or if you don't want that asset in your trust because you received an inheritance, it might be time to do a new trust just for that inheritance, for that separate property. So our key takeaways here is you're not SOL. Yes, that is a legal terminology. If you watched my webinars before, you heard me talk before, there is legal terminology called SOL. Figure it out. You know what it means. You are out of luck. You're not out of luck if you have a situation where there is a trust and an asset not on a trust and the person who created a trust died. You're not out of luck. We don't have to go through a full probate. Don't take probate for an answer. You go talk to counsel and they're like, hey, you know what? We're going to have to do probate on this one. Don't take probate for an answer. There is a potential solution. Now, you might not be successful with it because of the issues that may come up. Well, then you're back in probate, but you might as well take heed or take the opportunity to pursue a Heggstad, because even in a situation where it might not be as clear that's going to work, because the benefit is so much huger than the worst outcome. See how I say myself there. Huger is not a word. It's better to try the Heggstad and lose than to never Heggstad at all, right? It's better to love and loss than never to have loved. So give your probate estate, give your unfunded trust that you are inheriting or you're managing as a trustee some love, and try Heggstad. You want to make sure you have clear schedule of assets in your trust before you die. or go and talk to your parents or your older relatives, make sure that they have a clear schedule of assets in the trust, because that schedule in there is demonstrative of intent as well. And that's helpful when we don't, when we have situations where we don't have a pour over will, for example. Schedule of assets help. And just know that the super Heggstad, especially, that we can do, and anybody that works in trust administration, probate, and Contra Costa County knows can do, is super Heggstad to really, really benefit our clients. This is how we can help. If this is a situation that you're in front of and facing right now, all you need to do is schedule a Heggstad meeting with me or my team. Remember, I have another lawyer and another one coming on board, so there's 3 of us. So we have plenty of capacity to help you within your crunch time. So schedule a meeting to talk about the administration of the trust. So it'll be a trust administration meeting. We'll review the situation with you. And then if it's a Heggstad, you schedule a meet with us. We review the trust and the assets. Then we have you sign all the documents, submit it, and boom, we're going to get that back within weeks. So like I said, the fastest turnaround I've seen is 2 weeks. So that's pretty fast. And we can do it if you need that help. So have a great weekend. Enjoy your first weekend in May. You guys are wonderful, and look forward to coming at you next month.